The court is ready to hear argument in case number 2020-2021, William DeNolf against the city of Knerr. Petitioner, we're ready when you are.
Thank you, Your Honor. Before we begin, can we reserve 2 minutes for rebuttal? Your Honor, is my audio?
I'm sorry, I didn't hear you.
Before we begin, can we reserve 2 minutes for rebuttal?
Yes, you may.
Thank you. Chief Justice, Your Honors, and may it please the court. My name is David Korn, and I, along with my co-counsel, Randall Shirey, rise to represent the petitioner, Mr. DeNolf, with regard to his First Amendment claims. I'll be addressing the freedom of speech issue, while my co-counsel will be addressing the freedom of association issue. Citing to the case of United States v. Eichmann, the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. To this end, the petitioner has 2 points of argumentation. First, that Ordinance 417 should be held to the standard of strict scrutiny, and second, that it fails to pass strict scrutiny. With regards to my first point, this court established in Hurley v. Irish American Gay Lesbian Bisexual Group of Boston that regulations that compel speech are presumptively unconstitutional and must be held to the standard of strict scrutiny. As applied to Mr. DeNolf, the city of Knerr is compelling him to create art in celebration of a same-sex wedding, a message he cannot express, as doing so would violate his sincerely held religious beliefs. And it was recognized in Hurley that the First Amendment protects not only freedom from compelled speech, but the right to remain silent on issues one does not wish to speak on. And these same protections extend to Mr. DeNolf's art as they are pure speech.
Counsel, if I may interrupt you right there, it seems that that is the key question here is this art or not? And if I understand it right, it sounds like your client engages in some typesetting and perhaps some calligraphy. That's very different from traditional expression. So why should we conclude that this is art and protect it the way you want us to?
Yes, Your Honor. We should protect it as art because in Hurley, it established that some forms of art, such as painting a painting, are explicitly forms of pure speech. And if I may direct the court's attention to page 3, paragraph 4, on the banner Mr. DeNolf is being compelled to create, it is featuring a painting that he would paint custom for the wedding. He's being compelled to create hand-drawn calligraphy, the banner, and a custom frame that he would have full artistic discretion in the creation of. And as these—
the Hurley case was a case involving a parade, is that right?
Yes, Your Honor.
And is it fair to say that a parade is an event, the purpose of which is to express the message of the parade organizers?
Yes, Your Honor.
So is it the purpose of a business like this one to express the message of the business owners, or is it the purpose of a business like this one to express the message of whatever customers are paying them for their services?
Both would be protected, Your Honor, as Mr. DeNolf is both speaking and he is communicating ideas that originate from another speaker. And in the Hurley court, they did not limit themselves to the First Amendment protecting only free speech organizations that are nonprofits, stating that simply because a speaker sells their speech, they do not sacrifice their First Amendment protections.
Well, but counsel, I guess that's sort of one of the key questions here, isn't it? Which is the service that this business is selling that customers are paying for the privilege of promoting the business owner's message, or is the service that they are selling that they're placing their skills in service of whatever message the customer wants, but that the customer is the one whose message is being expressed? Isn't that right?
In this instance, Your Honor, both individuals, the customer and the actual artist furthering the message, would be speaking. In the case of Coleman, cited within Brush and Nib Studios v. City of Phoenix, also addressed a similar issue that dealt with tattoo artists, where the court found that both the tattoo artist and the person receiving the tattoo were speaking, and both could at any point choose to not express that message. Similarly here, Ms. C and Ms. Bill are providing logistical information and paying Mr. DeNolf for his services, and he is designing color schemes, creating custom art, and creating pure speech as was defined in Hurley. Thus,
in the case of the tattoo artist, what was the part of his speech? In other words, what was the art?
well, the art would be the artist engaging in a form of self-expression, Your Honor. And that is what was defined as being pure speech in Hurley.
But isn't this a little bit different? Because isn't this, in a sense, a thing where nobody who would reasonably look at these wedding decorations would think that it was the stationery store's art? You know, we're talking about the reasonable perception of others, right? So how is this not controlled by that?
Yes, Your Honor. The standard that you're proposing, which I believe is the Spence-Johnson test, as cited within Brush and Nib, would not be applicable in this instance because the Hurley court explicitly stated that when dealing with pure speech, it is erroneous to apply the Spence-Johnson test. And as Mr. DeNolf's custom art on the banner would fall under pure speech, and the regulation is compelling that speech, under the standard of NIFLA v. Becerra, that regulation is functioning as a content-specific regulation on his speech, stating that any regulation that forces an individual to speak when they would otherwise remain silent necessarily alters the content of that speech functioning.
Well, but counsel, NIFLA is a very different case, isn't it? I mean, NIFLA was a case in which the state of California mandated a specific message that certain types of institutions had to display. There's nothing like that here. This is just a general purpose anti-discrimination law. It just happens that this business is producing commercial goods and services that have an artistic component to it. So isn't that a very different situation?
This situation, while it is different in form from NIFLA, the principles underlying it are still applicable, which actually brings me to my second point, that as this is a content-specific regulation, it would not fulfill strict scrutiny as the state is pursuing the interest of viewpoint discrimination, which has never been upheld as either an important governmental interest or a compelling one. And this issue was actually fleshed out in the case of Hurley, which also dealt with a public accommodations law similar to Ordinance 417. The court stated that preventing discrimination only extends to ensuring equal access to publicly available goods, services, and privileges. However, it falls short of being able to compel speech itself, as Justice.
But the Hurley case, the court described the parade organizers in that case as a street corner speaker. And they actually used that term. And the reasoning of the court was that you can't take an anti-discrimination law and apply it to a speaker in a public square who is promoting their own message. Is that an appropriate characterization of this business?
Yes, Your Honor, because it was on the basis of Mr. DeNolf's message that he chose to not provide these services. The respondent may contend that it was because of the Miss C and Miss Bo's sexual orientation that Mr. DeNolf chose to refuse these services. But it was noted in Masterpiece Cake Shop v. Colorado Civil Rights Commission, as cited within the Lane Photography v. Willick, that the time and place and context in which art is displayed would have an impact on the message that is being expressed. When Mr. DeNolf was made aware that it was played at a wedding, the message shifted to one that did not violate his conscience to one that did violate his conscience.
Sorry to interrupt, but what if this were a case where it was something else that offended Mr. DeNolf, such as interracial marriage? Would you be making the same argument?
Yes, Your Honor, because while the society might find that objectionable, as in the United States v. Eichmann, Mr. DeNolf would still have the freedom of speech to choose not to express that message. However, he would not be able to deny pre-made goods that have no custom art. But because Mr. DeNolf is creating custom art and creating paintings for the wedding, that pure speech would be protected.
So then when does the compelling state interest in ending discrimination prevail over somebody's individual beliefs?
That would move on to the second prong, Your Honor, of the law not being sufficiently narrowly tailored. The state can compel and should have more narrowly tailored the law to only require that businesses may not deny non-expressive services, thus not being overly burdensome on Mr. DeNolf's speech, violating his First Amendment protections.
What other types of businesses would constitute providers of expressive services? How broad is that category, counsel?
That category for the things that were explicitly stated in Hurley would automatically trigger protections, Your Honor. But for something that would be on the fence, such as the photography in Hurley, the Spence-Johnson test would apply, and that would be on a case-by-case basis. Thus, we ask that you overturn the lower court's decision. Thank you.
Any other questions? Thank you, Mr. Korn. Mr. Shirey, we'll hear from you.
Mr. Shirey, before you begin, could you tell me which one of you two is going to be doing the rebuttal?
Of course, Your Honor. My co-counsel, David Korn, will be doing the rebuttal.
Thank you so much.
Thank you. Permission to proceed?
Please.
Thank you. Chief Justice, Your Honors, and may it please the court, my name is Randall Shirey, and I will be furthering the argumentation of my co-counsel, David Korn, and representation of the petitioner in today's case, Mr. DeNolf. I'll be representing the petitioner's contention against the constitutionality of Section 4B of Ordinance 417 as applied. Your Honors, looking to the case of Healy versus James, this court recognized that denying an individual government benefits or privileges based solely on their association is presumed unconstitutional, a violation of their First Amendment protections, and must be held to strict scrutiny within this court. And it's for the following two reasons we ask that the previous ruling of the lower court be overturned. First, that Section 4B of Ordinance 417 in its application violated Mr. DeNolf's right to freely associate, therefore must be held to strict scrutiny. And second, that when viewed through the judicial lens of strict scrutiny, Section 4B of Ordinance 417 fails.
Counsel, I don't see where the restriction is here. There's nothing in the ordinance that says that your client is not allowed to associate with whatever groups he wants. All it says is that the city has the right to choose who it wants to associate with. So where is the burden on your client's rights?
Of course, Your Honor, to answer this question, we must first establish that there is associational value behind financial contributions for there to be an associational violation in place in today's case. For this, we would look to two cases. First, the case of Keller versus State Bar of California, as cited within Johann's Livestock versus Marketing Association, where this court identified that private finances are inherently associational and essential to First Amendment privileges. And then again, in the case of Russ versus Sullivan, where this ideology was furthered, where this court recognized that finances are associational in value. Mr. DeNolf,
I'm not quarreling with the idea that there's associational value in financial contributions. I guess what I'm trying to figure out is where's the restriction? That there's nothing in this ordinance that says that DeNolf cannot make those contributions if he wants to. All it says is if he exercises that choice, he cannot also expect a contract with the city.
Yes, Your Honor. Mr. DeNolf's denial of a contract with the city would go to a case such as Healy versus James, where Mr. DeNolf is being denied a government benefit or privilege based solely on an association. In today's case, it is his financial association, which is privately furthering his beliefs or opinions. We can see this in the case of Broderick versus Oklahoma, where this court identified that individuals hold protections under the First Amendment's umbrella when privately expressing their beliefs.
So no matter how abhorrent someone's association may be to a state interest such as ending discrimination, the state still has to contract with that person, or in this case, the city?
Your Honor, I'm going to answer your question in two parts. First, in regards to the abhorrent viewpoint, we can see this ideology displayed in the case of United States versus Robel, where this court identified that no matter how offensive a viewpoint may be, the state cannot deny an individual associational rights and specifically a government benefit or privilege based on that association. And then to the second part, if Mr. DeNolf's association was combating a compelling state interest in today's case, specifically of discrimination, then the respondent may have standing. But
so what if Mr. DeNolf was contributing to or joining the Ku Klux Klan? Would the city still have to have a contract with him?
No, Your Honor. Turning the court's attention to the case of RAV versus St. Paul, historically established groups that are identified and associated with acts of violence towards marginalized groups, such as in the case of the KKK, African-American individuals, the government does not have to associate with them, surely. But in today's case, we're dealing with a private individual who is advancing his nonviolent beliefs and opinions to different groups that simply align with those.
So where's the line?
I understand your position. Does your position here depend on a value judgment between the odiousness of the KKK and the odiousness or lack thereof of the organizations that your client contributed to it? That's, I think, what I just heard you say, isn't it?
Not necessarily, Your Honor. Looking again to the case of RAV versus St. Paul, we can't necessarily look at the viewpoints of these different groups, but the actions caused by them. And we have to look at page 4, footnote 4 of the record to identify if there are any actions caused by these groups that would be combating a compelling state interest of discrimination. Facially, Ordinance 417 seeks to combat this discrimination, but through the application of Section 4B, it is not accomplishing this interest. We can see that
part of the record in this case indicates that there has been a rather disturbing spike in hate crimes against members of the LGBT community in this city in recent years. So if your focus is on not the city having a right, as Justice C put it, not to associate with people who are contributing to groups that may be promoting violence, as opposed to simply views that the city doesn't like, doesn't that create a record and an argument that your concession about the KKK may have at least some bearing on the current situation?
Not necessarily, Your Honor. As in today's case, we can identify through the record, page 4, footnote 4 specifically, that these groups were not associated with any acts of violence within the city. Therefore, the application of Section 4B towards Mr. DeNolf for financially associating with these groups would not be going towards any compelling state interest of discrimination. Facially, Ordinance 417, in its enactment and in its addition to these state contracts, was to combat this discrimination and those rises of hate crimes, as you previously mentioned. But in the application of Section 4B towards Mr. DeNolf, it was not accomplishing this compelling state interest, which lends to my second point that Section 4B in its application was not necessary to a compelling state interest, which is the first prong of the strict scrutiny standard. We can see there were two different state interests the city of Knerr has outlined, turning the court's attention to Section 2A of Ordinance 417. First, that of a fiscal concern, which this court has ruled can be a legitimate state interest, and second, an issue of tolerance. In regards to the fiscal concern, Section 4B in its application towards Mr. DeNolf was not necessary to accomplishing any kind of fiscal health within the economic square. Referencing page 4, footnote 4 again of the record, these different groups were not associated with any acts of violence. They simply held an ideology or a belief that the government deemed to be abhorrent, which has been ruled to be unconstitutional in cases such as United States versus Robel, and something that is unconstitutional to deny an individual government benefits or privileges based off of. And then on the issue of tolerance, it is an important distinction that needs to be made within this court between discriminatory acts, specifically hate crimes in today's case, and tolerance of ideas. We can see that discrimination in
Counsel, what if this were not a case of a strict prohibition on contracting with someone like your client, but if the ordinance simply said that the city has a preference, it prefers working with businesses who have not associated with these certain groups? If it was a preference and not an absolute rule, would that change the constitutional analysis?
Yes, not necessarily in today's case, Your Honor, as we can see that Ordinance 417 by the city of Knerr was not to be applied retroactively to individuals who had possibly violated these before entering the contract. But Mr. DeNolf's First Amendment protections still hold even if he is in a contract with the state. And this lends to the second prong of the strict scrutiny test, which is its narrowly tailored application. And if there is any narrowly tailoring of the application of Section 4B, which in today's case, Section 4B in its application could have been more narrowly tailored to accomplish that state interest of discrimination if it only targeted groups that were perpetuating violence against LGBT individuals within the city. In today's case, we can see that these different groups were not perpetuating any violence, and Mr. DeNolf was not reported to perpetuate any violence as well.
So the city has to wait for people to be hurt or threatened with harm before it can express its own associational preference?
No, Your Honor, but the state simply cannot establish correct ideas. And these different ideologies are not inherently violent in themselves, but specifically a belief that Mr. DeNolf and these different groups hold. And Mr. DeNolf, through his financial associations, was privately expressing and furthering this belief, and subsequently, his government benefit was denied because of this. Therefore,
Mr. DeNolf has no right to a city contract.
Yes, Your Honor. I see my time is about to expire. May I briefly answer your question?
Yes, please.
Yes, Your Honor. For this question to be answered, we'd look to the case of Healy versus James, where this court clearly identified that whether it's a government privilege or a government entitlement or government benefit, if it's denied based off of an individual's association, then it's an associational rights violation and must be held to strict scrutiny. And for the previous two reasons, we ask that the previous ruling of the lower court be overturned and Mr. DeNolf's First Amendment rights be upheld. Thank you.
Any other questions? Thank you, Mr. Shirey. We'll hear from the respondents.
Mr. Chief Justice, may I proceed?
You may.
Mr. Chief Justice, Associate Justices, and may it please the court. My name is Janson Requist, and I, along with my co-counsel, Courtney Requist, represent the respondent, the city of Knerr, in the case at bar. I will be addressing the freedom of speech issues, and my co-counsel will address the freedom of association issues. The First Amendment, as applied to the states through the 14th Amendment, requires that Congress shall make no law abridging the freedom of speech. In the case at bar, the city of Knerr upheld this fundamental right while simultaneously ensuring that public accommodations must serve all citizens equally. We respectfully request that this court find this action by the city of Knerr was constitutionally acceptable for two main reasons. First, the city's fair application of Ordinance 417 to Mr. DeNolf should be evaluated under intermediate scrutiny. And second, the actions of the city satisfy both intermediate and strict scrutiny. Turning to the first point as to why intermediate scrutiny is the appropriate standard for this case. This court has long recognized that intermediate scrutiny should be applied in two main instances. First, if a business is acting merely as a conduit for the ideas of others, or second, if that business is regulated by a content-neutral form of legislation. Both of these prongs are present before the court today. To the first point, Mr. DeNolf's business acts as a conduit for the ideas of others. To elucidate this, we invite the court to turn its attention to Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston. In that case, the court established two prongs for determining when a business is a conduit. First, does that business possess autonomy? Or in other words, final say, as made clear in its references to Miami Herald Publishing Company versus Tornillo within Hurley. And second, is there a likelihood of a public association between the speaker and the finished message? Mr. DeNolf satisfies neither of these prongs. To the autonomy point, Mr. DeNolf himself may be involved in this creative process, as argued by petitioner, but mere involvement in the creative process is not enough. As this court has noted in Hurley, a speaker must be autonomous. Now, petitioner relied on
surely it's the case that part of Mr. DeNolf's business model is that he has a signature style, a signature artistry, and that when he produces work, people know that it's his work. And presumably that's part of what makes him a success, is that he's good and he's distinctive. And as I understand your colleagues on the other side of this argument, they're suggesting that you can't separate those two things. You can't suggest that there's not going to be an understanding, a perception that his artistry has been placed in service of a message that he doesn't approve of. And so how do you deal with that argument?
Your Honor, we do not deny that Mr. DeNolf may offer a unique service, but there's a low likelihood of public association between him and the finished message for two reasons. First, nowhere in the record does it ever indicate that Mr. DeNolf puts his company name, logo, or other branding information on the products that he'll make for this couple. This stands in stark contrast to Miami Herald as cited in Hurley, where the newspaper published the editorial page under its own name.
But counsel, I'm sorry.
Does your position depend on that proposition?
My apologies, Your Honor, I couldn't hear with the audio.
I'm sorry, does your position depend on that proposition?
No, Your Honor, for two reasons. First, the second response to Associate Justice's previous question is that even if someone were to find out this is Mr. DeNolf's work, say, for instance, through his unique style, there's still a low likelihood of public association, given that Mr. DeNolf advertises his product not as a unique service, but as a conduit for others' ideas. As noted on page 2, his business is named Indulging Your Creativity. He advertises his slogan, "If you can imagine it, we can create it." And he even guaranteed these customers on page 3, paragraph 5, quote, "We will express whatever message you want through our work."
Counsel, how can it be that he is just a conduit when it's if you go to somebody's wedding, right? Just think when you've gone to a wedding, you might say, well, who did your beautiful decorations? And of course, then they're going to tell you it was DeNolf. And there's going to be an association that he has placed his imprimatur on this wedding. So how is that not his expression?
For two reasons, Your Honors. First, Mr. DeNolf, again, may have a unique artistic style. However, Mr. DeNolf advertises his business both to the public and guarantees it to these customers as a means of channeling others' ideas, not his own. But secondarily, even if he said otherwise, he lacks final say over the finished product. So a person at that wedding who picked up the product not only would not necessarily know it was his product, even if they did know, would know that he advertises himself as a conduit.
Well, so what about the argument from opposing counsel that this isn't just arranging words artfully on a page, but there's also a custom banner involved? I mean, that seems to be squarely in what we would traditionally think of artistic expression if there's a painting. So how does that piece factor into your analysis?
In two ways, Your Honor. First, this court has never extended protection to public accommodations that engage in artistic expression, as noted in Elaine Photography LLC versus Willock. In fact, the case relied on by petitioner Coleman, as cited within Brush and Nib Studios versus City of Phoenix, is only an Arizona Supreme Court case cited within another Arizona Supreme Court case. But secondarily, Your Honor, even if this court were to hold Mr. DeNolf as an active participant sufficient for receiving protection, Mr. DeNolf doesn't have the final say over that banner. He may offer suggestions and draw mock-ups, but ultimately whether that banner is accepted and shown at the wedding is entirely up to his clients because it's their wedding, not his own. This is very different than the newspaper in Miami Herald. However, Your Honors, even if this court—
So let me ask you this. Is art always free speech? In other words, is art always speech? Always?
Yes, Your Honor.
Okay, so what is art?
Your Honor, all art would be something that satisfies the Spence-Johnson test as alluded to by petitioner. However, the key distinction between this case and something like Brush and Nib Studios dealing with art is that Mr. DeNolf's art is not expressing his own message, but the messages of other people.
Shouldn't it be the artist who defines whether he is an artist or not? This is my art, and therefore we have to take him at his word that this is art, and therefore is this free speech?
No, Your Honor. This court has never respected the right of someone to merely invent a constitutional right because they claim it as their own. They must have a demonstration of autonomy and public association. And this taps into something else brought up by petitioner about Mr. DeNolf's conscientious objection. This court in Hurley required that for an artist to be autonomous, they must demonstrate a history of screening out messages that they find objectionable. In this case, Mr. DeNolf has not satisfied this burden and has never presented this court with any prior instances of screening out a message that he found objectionable that wasn't connected to the protected class of LGBTQ individuals.
But really, doesn't this get down to the city of Knerr requiring businesses within its limits or who are providing services to its citizens to embrace a particular viewpoint?
No, Your Honor, and that turns to Respondent's second argument, that this is a content-neutral form of legislation. Petitioner argued that because this statute compelled Mr. DeNolf to say something he otherwise would not have, that this is an as-applied content-specific law. However, that directly contradicts this court's precedent in Turner Broadcasting Systems, Inc. versus FCC, as cited within Hurley. In Turner Broadcasting, the court upheld the right of government to require a broadcasting company to share messages that they otherwise would not have, because as this court noted and as Associate Justice alluded to in questioning, it's acceptable to regulate speech as long as that speech just so happens to be connected to another activity. To use the words of Johans versus Livestock Marketing Association, if that speech is incidental to other speech. This is very different than NIFLA versus Becerra, as pointed out by Associate Justice in prior questioning, where the message was pre-scripted, pre-known, and incredibly precise. The statute from the city of Knerr, as seen in footnote 3, as well as in Appendix 1, merely requires equal service for a variety of protected classes.
Counsel, if I may, Hurley was an as-applied challenge to an otherwise unobjectionable public accommodation statute. Isn't that right?
Yes, Your Honor.
And so your opponent's argument is that this is too. And your opponent's argument is that businesses that offer expressive goods and services should be recognized as an as-applied problem for an otherwise unobjectionable anti-discrimination law. And the argument about Turner is an interesting one, although it's a different situation. That's another case in which the government was actually picking, in this case, channels of programming and saying you have to carry those, right? But here, this is compelling an artist to create art. And why is that not an appropriate as applied challenge in the same way that Hurley was?
Two responses, Your Honor. Before proceeding, Mr. Chief Justice, I see my time is drawing to a close. May I answer the Associate Justice's question and briefly conclude?
Yes, please.
Thank you, Your Honor. Two reasons, Your Honors. First, this court has never held that applying a content-neutral law in a specific instance suddenly makes it content-specific. To do so would prevent any content-neutral law from ever actually being enforced. Rather, the question of the court, in even an as-applied challenge, such as Hurley or Turner Broadcasting, is whether the law itself is neutral towards content. But secondarily, Your Honor, as alluded to you by your question and by petitioner's request for a carve-out, this court has recognized that just because an alternative may be less burdensome, creating carve-outs for speech-related public accommodations doesn't mean it would be any effective at achieving the state's interests, as evidenced by the fact that petitioner's counsel has conceded that under their proposed solution, a case-by-case Spence-Johnson test would be required for every business, and businesses could discriminate against interracial couples. This is a devastating public policy consequence. It's for these reasons that we ask this court to affirm the decision of the lower court. Thank you.
Any other questions? Thank you, Mr. Requist. Ms. Requist, we'll hear from you.
Chief Justice, Associate Justices, and may it please the court. My name is Courtney Requist, and I will be continuing arguments for the respondent. This case is about an individual who is attempting to reassert rights he voluntarily chose to relinquish under constitutional conditions. Therefore, we respectfully ask this court to affirm the lower court's decision for three reasons. First, the petitioner willingly accepted the constitutional conditions placed upon him. Second, the most appropriate level of scrutiny to apply to this case is intermediate. And third, the actions by the city of Knerr fulfill intermediate and strict scrutiny. Turning to my first point, Your Honor, the petitioner willingly, knowingly, and voluntarily accepted the constitutional conditions placed upon him. This is important to note for three reasons. First, the government may place conditions upon those receiving any kind of governmental funds. Second, the petitioner accepted these conditions. And third, the petitioner knowingly violated these conditions. Turning to the first point, before proceeding, it's important to note that the respondent respectfully disagrees with the petitioner's characterization of Russ versus Sullivan. In that case, the government was indeed dealing with association and funding, but its own association and funding, and whether or not it was entitled to associate and fund who it wanted. It wasn't dealing with the individual's right of association or their ability to associate with the government, but rather the government's ability. But furthermore, this is the most analogous case to the case at bar, because in that case, it described that the government is entitled to place conditions upon those receiving government.
Also, I'm curious about your voluntarily accepted the conditions argument. It seems in that case, the only way you would think that DeNolf would have a case is if he refused the contract and then tried to challenge the ordinance. It seems that there can be plenty of conditions that could be unconstitutional. And how does the mere act of accepting the contract forfeit any right to challenge those conditions?
Absolutely. Two responses, Your Honor. First, if the law on its face is unconstitutional, then that poses a different question of whether or not its conditions are constitutional indeed. But secondarily, the petitioner entered into these constitutional conditions and then knowingly violated them, which is very important to note because under the case of Healy versus James, the one reason why associational rights can be restricted is if a petitioner demonstrates that they are unwilling to comply with policy. That is precisely what is happening in the case at bar. Contrary to petitioner's claim, the petitioner was not, his contract was not continued because of mere association, but rather because he demonstrated that he was unwilling to comply with policy. But furthermore, he did.
But isn't that just another way of saying his contract wasn't continued because a law that he says is unconstitutional was being applied against him?
Your Honor, and the law is not constitutional or unconstitutional as applied or on its face for two reasons. First, because it demonstrates an important governmental interest, if not compelling. And second, it is substantially related and narrowly tailored in order to achieve this interest, which turns me to my second point.
So, but how is what happened to DeNolf in any way connected with, I mean, what the city actually was trying to do was to force him as a condition to keeping his contract to donate money to organizations that he did not support. So that's almost a forced association to receive a benefit that perhaps he was entitled to receive without any interference with his association.
No, Your Honor, and we respectfully invite this court to evaluate the case of Rebel versus United States for clarification, as that serves as a very distinguishable case from this case. In that case, an individual was subjected to a $10,000 fine that was required and imprisonment for being merely associated with the Communist Party under the Subversive Activities Control Act. The petitioner in our case was merely asked to donate $500 to 4 groups in order to serve as a remedy. This is distinctly different than cases that have applied strict scrutiny because it's not a required consequence or punishment. It serves as an opportunity or an option or a choice in which the petitioner has the opportunity to say no to.
And if the city's aim was something other than countering discrimination, if the city, for example, decided to promote discrimination, would we still be having this same argument that its actions were constitutional?
Your Honor, under this court's precedent in RAV versus St. Paul, anti-discrimination has long been upheld by this court as a compelling governmental interest. Therefore, if the government was blatantly discriminating based on viewpoint, then that would be a different conversation. But with this 2 responses, first, nothing within our record demonstrates that the petitioner had his contract rescinded because of his viewpoint. It's rather because he donated to groups in which are advancing intolerance and the lack of protection of civil rights.
Well, counsel, good heavens. I mean, how is that not a viewpoint? I mean, the case that you just cited, RAV, stands for the proposition that a city cannot criminalize speech that it views as odious and hateful, because that constitutes targeting a disfavored viewpoint. And it sounds to me like what you've just described is exactly the same thing, except the mechanism for targeting that speech is denying you a city contract rather than prosecuting you under a city ordinance. Why isn't that the exact same thing?
Your Honor, 2 responses. First, it's distinguishable because the petitioner himself has demonstrated that he is unwilling to comply with policy, which under this court's precedent in Healy constitutes a constitutional violation of associational rights. But secondarily, within the city of Knerr, the hate crime towards LGBT individuals is 30.1%, which is double the national average of 16.1%. The city of Knerr should be granted deference in dealing with what they determine to be hate groups because it's contributing to crime within the city of Knerr statistically higher than the national average. But furthermore, Your Honor, under the petitioner's claim, if we were not able to take into viewpoint when determining legislation, we would not be able to produce legislation that fights against discrimination. But furthermore, this would allow things like individuals who do not agree with interracial marriage or agree with other things like child molestation to do whatever they want because they merely claim it as a belief that is acceptable. Under this kind of condition, we would be tying the hands of the government in determining what is best for their citizens objectively through the statistics that are indicated within our record.
Counsel, pardon me for interrupting, but what you've just described is a series of viewpoints that I think many would characterize as odious. And what you're arguing is that the city needs to have the right to, it sounds like, eradicate those viewpoints by using the financial leverage of denying city contracts. Why isn't that a directly contradictory to the principles underlying RAB?
There are 2 responses, because the city is not attempting to eradicate, but rather to decrease the amount of hate crimes within the city of Knerr, which is statistically very high within their population. But secondarily, under the petitioner's precedent, the government would only be able to react to violence. That's a really high standard in applying legislation, and the government should be granted deference to not only react, but to proactively create legislation in which their city desperately needs, which is present within this case.
Counsel, related to that, this case has become extremely timely in light of terminating relationships with people who participated in the insurrection at the Capitol a couple weeks ago. If the city of Knerr were to enact this ordinance and amend it to say that it will not contract with anyone who participated in or contributed to that event, would that be appropriate under your rule?
Your Honor, under this court's precedent in Ling versus automobile workers, perhaps, for 2 reasons. First, if there's a demonstrated history of violence of the individual itself, then yes. And secondarily, if it's contributing to economic harm in which the petitioner has demonstrated as an important governmental interest.
This is a one-time event. We don't have the history factor. How does that change the analysis?
It would be unclear within the facts presented to the respondent of we could associate or we could restrict association with those groups. But if they could demonstrate that they were planning another violent attack or they are associated with groups that were decreasing economic health, then yes, under this court's precedent in Ling versus automobile workers, the respondent would be entitled to do such, which I respectfully turn this court's attention to the case of Ling versus automobile workers, which defines substantial interference as economic or physical reprisals. This is distinctly different than the case of Broderick versus Oklahoma, where that individual was fired from his job and lost his entire livelihood because of mere association with a group. This is once again not present within the case at bar because the petitioner himself on page 4 of the record quoted, "I'll be damned if I lose $2,500 over a $7,500 contract." It's very clear that this is distinguishable from cases that apply strict scrutiny because the individual is not being subjected to economic reprisals as determined as appropriate by this court, and is also not being subjected to criminal sanctions. As questioned to opposing counsel earlier, he can still associate with whomever he wants in whatever way he wants, except for contributing funds in which he has received from the government. This has been long upheld by this court as an important governmental interest. And under cases such as Rust versus Sullivan and Walker versus Sons of Confederacy,
what if the ordinance were tailored so narrowly as to allow an exception for the person to sequester any funds they receive from the city and donate only other funds to these groups?
Chief Justice, I see my time is about to expire. May I briefly answer the question and conclude?
Yes, please.
Your Honor, if those donations were contributing to hate crime or intolerance or not protecting the civil rights of individuals, and they could demonstrate that the petitioner was aware of the conditions that were placed upon him, then once again, he would be able to have those rights restricted because he voluntarily entered into conditions in which he has experienced here. So for these reasons, we ask the court to affirm the lower court's decision and favor the respondent. Thank you.
Any other questions? Thank you, Ms. Requist. Mr. Korn, I believe you have 2 minutes.
May I proceed?
Please.
Brief rebuttal, Your Honor. First, regarding the freedom of association issue. The respondent's contention is that it depends on the severity of a burden, whether or not one's associational rights are burdened, triggering the strict scrutiny standard. But this is contrary to what was established in Healy v. James, which stated that any burden, no matter how small, if it is a burden on an associational right, the strict scrutiny standard applies. Now moving on to the freedom of speech issue. The respondent rested heavily on the case of Turner Broadcasting Systems. But as Justice Wolf pointed out, there are some significant differences between that case and this case, because in Turner, the cable companies were not required to create part of the programming for the newscasters. They did not have to alter the programming. They merely allowed them access onto the cable network's actual hardware. Mr. DeNolf is going much more beyond that, in that he is actually creating art in pure speech for Miss C and Miss Bo's wedding. And as Justice Somerville, in his questioning to the respondent conceded that all art is a form of speech, so long as it passes the Spence-Johnson test. While that test would not apply, as Mr. DeNolf's art is pure speech, if it were to apply, it would still fall under protected status, as it meets both prongs. First, Mr. DeNolf does believe he is engaging in a form of speech, as is evident in the record. And the rational third-party observer would recognize a message that is being expressed.
Counsel, if we disagree with your characterization of the customized nature of this product, do you lose this case?
No, Your Honor, because under the second prong of the Spence-Johnson test, 2 messages would be acknowledged: that the event at which the art is displayed is a wedding, and second, that the wedding is something to be celebrated. Thus, we ask that you overturn. Thank you.
Thank you, Mr. Korn. That concludes the arguments in the case, and the case is submitted.